Hello viewers, I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. In the present module, we will learn about property in Hindu law, kinds and sources. Learning outcomes of the present module are firstly introduction, then joint family property or coparcenary property, that is apratibandh daya, then separate property or sapratibandh daya, and finally the conclusion. Let's begin with a brief overview. We have covered the Hindu joint family as a distinctive concept in Hindu jurisprudence in the previous lectures. One of the most significant characteristics of a Hindu joint family is joint family property. Mitakshara law recognizes two distinct types of property. Firstly, joint family property or coparcenary property, that is apratibandh daya. Secondly, separate property or sapratibandh daya. Now let's discuss joint family property or coparcenary property or apratibandh daya. The other term used for joint family property is coparcenary property or unobstructed heritage. It is also popularly called ancestral property. It is to be noted that ancestral property is one of the species of the joint family property, whereas joint family property is the genus. Joint family property consists of ancestral property, properties acquired through joint family property, accretions made to joint family property, etc. Joint family property means property jointly owned by all the copartners of a Hindu joint family. It is the property in which all the copartners have a community of interest and unity of possession. Property in which a person acquires an interest by birth is called unobstructed heritage. It is called unobstructed because the accrual of the right is not obstructed by the existence of the owner. It implies a heritage that moves on from generation to generation, and no generation can create an obstruction in its way. Simply put, an ancestor is not empowered to disinherit his successors from inheriting the ancestral property owned by him. Incidents of joint family property are as follows. Firstly, ancestral property. Ancestral property means, as regards sons, property inherited from a direct male lineal ancestor, and as regards collateral, property inherited from a common ancestor. Ancestral property may be defined as the property that a man inherits from any of his three immediate male ancestors, that is, his father, grandfather, and great-grandfather. Therefore, property inherited from any other relation is not treated as ancestral property. Ancestral property connotes property belonging to an ancestor and passed on to his successors. Under Mitakshara law, ancestral property is the property that one inherits from his preceding three generations. Thus, property inherited from one's father or father's father or father's father's father is termed ancestral property. According to Mitakshara law, if an ancestral property is inherited by a Hindu, his succeeding three generations, that is, his son, son's son, and son's son's son, will have inheritance rights by birth. In Purnabai and others versus Ranchhod Das and others, 1992, the court observed that merely because the families are living separately, the nature of the joint family property will not be changed unless there is a partition, division, or settlement. Therefore, the properties continue to be a joint family properties only. Next is share obtained on partition. A share received in partition by a co-partner is ancestral property qua his successors and separate property qua the persons with whom he has partitioned. In C. Krishna Prasad versus CIT Bangalore 1975, the court was considering a similar question. In the said case, the appellant, along with his father and brother, formed a Hindu undivided family up to October 30, 1958, when there was a partition between the father and his two sons. A question arose as to whether an unmarried male Hindu on the partition of a joint Hindu family can be assessed in the status of an undivided family, even though no other person besides him is a member of the family. It was held that the share that a co-partner obtains on partition is ancestral property as regards male issue. It was held as under the share that a co-partner obtains on the partition of ancestral property is ancestral property as regards his male issue. They take an interest in it by birth, whether they are in existence at the time of partition or are born subsequently. Such share, however, is ancestral property only as regards his male issue. As regards other relations, it is separate property. And if the co-partner dies without leaving male issue, it passes to his heirs by succession. A person who for the time being is the sole surviving co-partner is entitled to dispose of the co-partnership property as if it was his separate property. He may sell or mortgage the property without legal necessity, or he may make a gift of it. If a son is subsequently born to him or adopted by him, the alienation, whether it is by way of sale, mortgage or gift, will nevertheless stand, for a son cannot object to alienations made by his father before he was born or begotten. Then there is property received as Class 1 heir under Section 8 of the Hindu Succession Act 1956. This pivotal issue was discussed by the Honorable Supreme Court in the landmark case Commissioner of Wealth Tax Kanpur and others versus Chandra Sen and others 1986 as follows. Under the Hindu law, the moment a son is born, he gets a share in the father's property and becomes part of the co-partner. His right accrues to him not on the death of the father or inheritance from the father, but with the very fact of his birth. Normally, therefore, whenever the father gets property from whatever source, from the grandfather or from any other source, be it separate property or not, his son should have a share in that. But this position has since been affected by Section 8 of the Hindu Succession Act. Since the preamble of the Act reiterates that Act is to amend and codify the law, and Section 4 thereof makes it clear that one should look to the Act in case of doubt and not to the pre-existing Hindu law. The express words of Section 8 of the Act would prevail over the aforesaid general law. When therefore a son inherits the property in the situation contemplated by Section 8 as a Class 1 heir, he does not take it as karta of his own undivided family, but takes it in his individual capacity, and it will be his separate property. It is to be noted that the schedule to the Act referred to in Section 8 Clause A indicates heirs in Class 1 and only includes the son and does not include the son's son, but does include the son of a predeceased son. The judgment clearly lays down that the property inherited by a Hindu As a class 1 heir of a deceased Hindu male, under Section 8 of the Hindu Succession Act 1956, is his separate property and not his ancestral property. However, the share received in partition amounts to ancestral property. Then, what is the effect of severance of status by unilateral declaration? This crucial issue came before the Supreme Court in Bhagwant P. Sulakhi versus the Gambak Gopal Sulak and others 1986. The court held that the character of any joint family property does not change with the severance of the status of the joint family, and a joint family property continues to retain its joint family character as long as the joint family property is in existence and is not partitioned amongst the co-sharers. By a unilateral act, it is not open to any member of the joint family to convert any joint family property into his personal property. It is to be noted that the partition of a Hindu joint family may take place in two steps. Firstly, there is severance of status and then actual partition by metes and bounds. What about accretions to joint family property? All assets acquired with the assistance of joint family property shall be regarded as joint family property. A plot or apartment purchased from joint family property, for instance, will be considered joint family property. Property thrown into common stock. If a member of a joint family puts his separate property into the common stock, a question arises as to whether such property becomes joint family property or retains the character of a separate property. The Supreme Court in S. Subramaniam versus S. Ramaswamy 2019 observed that law on the aspect of blending is well settled, that property separate or self-acquired of a member of a joint Hindu family may be impressed with the character of a joint family property if it is voluntarily thrown by the owner into the common stock with the intention of abandoning his separate claim therein. But to establish such abandonment, a clear intention to waive separate rights must be established. Clear intention to abandon the separate rights in the properties must be approved. Even abandonment cannot be inferred from merely allowing other family members also to use the property or the utilization of the income from the separate property out of generosity to support the family members. Another important property is lost property recovered. Joint family property lost to the joint family and subsequently recovered by a member thereof without the assistance of joint funds from a stranger holding adversely to the family will be, firstly, if recovered by Karta, his separate property, irrespective of the fact that the property is movable or immovable. Secondly, if recovered by any other co-partner, his separate property in the case of movable property, and in the case of immovable property, he will get 1/4 of the property as his separate property and the remaining property will be joint family property. Dear learners, let's understand the nature of property in the hands of sole co-partner. In M. Yogendra and others versus Lilamma N and others 2009, it was held as under. It is now well settled in view of several decisions of the court that the property in the hands of a sole co-partner allotted to him in partition shall be his separate property, for the same shall revive only when a son is born to him. It is one thing to say that the property remains a co-partnery property, but it is another thing to say that it revives. The distinction between the two is absolutely clear and unambiguous. In the case of the former, any sale or alienation that has been done by the sole survivor co-partner shall be valid. Whereas, in the case of a co-partner, any alienation made by the karta would be valid. In Rohit Chauhan versus Surendra Singh and others, 2013, a contention was raised by the defendant number 1 that after the partition of the joint Hindu family property, the land allotted to the share of defendant number 2 became his self-acquired property, and he was competent to transfer the property in the manner he desired. It was held that the property that defendant number 2 got by virtue of a partition decree amongst his father and brothers was although separate property qua other relations, but it attained the characteristics of co-partnership property the moment a son was born to defendant number 2. Then there are properties acquired by joint labor. It is well settled that when members of the joint family by their joint labor do the business and acquire properties, the properties so acquired in the absence of an intention to a contrary effect would be the joint family properties. When a joint family is found to be in the possession of a nucleus sufficient to make the impugned acquisition, then a presumption arises that the acquisitions standing in the name of the persons who were in the management of the family properties are family acquisitions. Dear learners, now we will discuss separate property or sapratibandhaya or obstructed heritage. The property to which right accrues not by birth but on the death of the final owner is called obstructed property. It is called obstructed since the accrual of the right to it is obstructed by the existence of the final owner. Separate property means property on which an individual has absolute interest. It is pertinent to note that a member of the Hindu joint family may own separate property along with his share of the co-partnership property. The concept of separate property can be explained as follows. Firstly, gains of learning. According to Yajnavalakya, the self-acquisition of an undivided co-partner would be whatever else is acquired by the co-partner himself, without detriment to his father's estate. Gains of learning, as the phrase implies, are profits obtained by one's own ability, skill, or learning. A painter earns money from his art, a mechanic from his skills, a teacher from teaching, and so on. Property earned through one's own learning or skill amounts to separate property of a person. The property earned through one's own labor is his separate property, and he exercises absolute control over it. Earlier, it was considered that if a co-partner has learned some skill or gained knowledge or education with the aid of joint family property, the property earned through such skill, knowledge, or education shall also belong to the joint family. However, with the passing of the Hindu Gains and Learning Act 1930, it has been made clear that property earned through one's own intellect, skill, etc. is his self-acquired property and not joint family property. Blending of separate property into the joint family pool. In P.N. Venkata Subramaniam Iyer versus P.N. Ishwara Iyer and others, 1966, the court, while quoting Maine, observed that where a man is dealing with the income from his separate property, the fact that he does not keep separate accounts and chooses to blend that income with income from a source of joint property cannot affect the corpus of the separate property itself. Supreme Court in Vemuru Venkata Krishnaiah versus Vemuru Lakshamma 1943 observed that a clear intention to waive separate rights must be established. Thus, if a separate property is blended into a joint family pool, it still remains separate property. Then there are salary and remuneration. Salary or remuneration received by an individual is his individual or separate property. In Commissioner of Income Tax versus Shri D.C. Shah, 1969, the Karta had rich experience in the line of business carried on by the firms. In one of the firms, the Karta was appointed as its managing partner and paid remuneration for the same. The court held that remuneration received by the Karta was his separate property. When a co-partner receives payment for his services, it becomes his own property rather than the joint family property. The wages that a co-partner receives from the joint family accounts in his capacity as a legal advisor, for instance, will be his separate property and not the joint family's property. If he is a lawyer by profession and serves as a legal advisor to a business held by his Hindu joint family. In Rajkumar Singh Hukamchandji versus Commissioner of Income Tax Madhya Pradesh 1971, the Supreme Court held that the broader principle to be seen is whether the remuneration received by the co-partner was one of the modes of return made to the family because of the investment of the family funds in the business, or whether it was a compensation made for the services rendered by the individual co-partner. If it is the former, it is an income of the Hindu undivided family. But if it is the latter, then it is the income of the individual co-partners. Then there are government grants. Where a government grant is allotted to a co-partner, it will be his separate property. However, if the same has been allotted in the name of a joint family, it will be considered joint family income. Property received through gift or will. A property received through a gift or will amounts to separate property of the individual. Another important point is insurance money. The general principle of Hindu law is that assets that have been acquired out of the funds of a joint family belong to the joint family. However, this position does not hold good in the case of money received under the insurance policies on the life of a member of the family. In Shrimati Radha Devi Sarogi versus Controller of Estate Duty, 1968, the court held that insurance policies are altogether on a different footing than other assets. If assets are acquired in the name of a member of the Hindu undivided family, out of the funds belonging to the Hindu undivided family, then generally these assets will form part of the estate of the Hindu undivided family, to which the particular individual belongs. Monies realized on accounts of insurance policies, however, will in no circumstance form part of the estate of the Hindu undivided family. They are entirely connected and dependent upon the life of the individual. This is the basic difference. The individual is the absolute owner of the policies. Insurance companies recognize him as such. He can nominate anybody he likes. The nominee can even be an outsider. He can even change the former nomination. He can raise loans on those policies. The policies are thus his absolute property and can be disposed of by him in any manner he likes. Next is property obtained by a daughter from joint family property. Property obtained by the daughter from the joint family property would be her absolute property. Any income therefrom is chargeable to tax in her hands in the individual status only. This will also apply to any legal heir obtaining property in the capacity of a descendant. Next is compensation. Compensation made for the services rendered by the individual co-partner is the separate income of the individual co-partner. Next is property received from maternal grandfather. A full bench of the High Court of Punjab in Musammat Atar Kaur versus Nikku 1924 observed that there was a great deal to be said in favor of the proposition that unless the land came to a person by descent from a lineal male ancestor in the male line, it should not be treated as ancestral. Under the customary law of Punjab, property inherited by a Hindu male from his maternal grandfather is not ancestral property for his sons. In Maktool versus MST Manbhari and others, 1958, the court held that under Hindu law, it is now clear that the only property that can be called ancestral property is property inherited by a person from his father, father's father, or father's father's father. Dear learners, let's conclude today's lecture. Joint family property or ancestral property means property inherited from a paternal ancestor. All property inherited by a male Hindu from his father, father's father, or father's father's father is ancestral property. And any property inherited by a person from any other relation is his separate property. The essential feature of the ancestral property, according to Mitakshara law, is that the sons, grandsons, and great grandsons of the person who inherits it acquire an interest and the rights attached to such property at the moment of their birth. It is to be noted that after the amendment of 2005, the Hindu Succession Act 1956, daughters are also entitled to share in joint family property at par with the sons of the family. Even if a Hindu is a member of a joint family, he may possess separate property. The term self-acquired indicates that the property has been acquired by the co-partner by his own exertion without assistance of family funds. Separate property includes self-acquired property. With this, we come to the end of today's lecture. Thank you very much.